How do I schedule a family law hearing? This video is an overview for filing and completing a non-emergency request for order. The information provided in this video is general and it may not apply to your case. Before we get started, very important, you must have an open case with the court in order to request a hearing. You can open a case by filing a petition with your request. Contact our Self-Help Center for more information on your options. What forms do I need? Request for order FL-300, attachment MC-025. With hearings regarding financial issues, you must also submit an income and expense declaration FL-150. And a proof of service. Depending on your mode of service, you can either use proof of personal service, FL-330, or proof of service by mail, FL-335. More on this later. This video provides general information regarding forms. There are some attachments that are needed for unique circumstances. These forms and attachments will be referred to within your forms. If you have questions about this, you can call the Self-Help Center for more information. What are the costs? If you haven't already opened a case or previously filed a response or answer, the first appearance fee is $450. The request for order fee is $60. The additional fee if you are modifying custody and/or visitation is $25, and the court reporter fee is $30. Can I apply for a fee waiver? If you have low income or cannot afford to pay the fee to file your court papers, you can ask for a fee waiver by completing forms FW001 and FW003. Step 1. How do I fill out my forms? There are three main parts of the request for order. Page 1 describes the details of when the hearing will be, what it will be about, and who should go. Pages 2 through 4 tell the judge specifically what you're requesting, what your current orders are, and why the judge should grant your request. Page 4 and any attachments tell the judge the facts that support your request. The Self-Help Center has compiled all the forms listed previously into a convenient form packet. They are available on our website at www.riverside.courts.ca.gov/flpackets. Under the section entitled Other Family Law Form Packets, you will find a packet entitled Request for Order Non-Emergency. Now that you have the Request for Order packet, fill in all of the information requested on the first page. This will auto-populate the basic information from your case into the forms. Couple notes. Enter the parties' names exactly as they appear in the initial petition, even if they've changed. The petitioner in the case is always the person who filed the initial petition, and the respondent is always the other party. Moving on to page 1 of Request for Order FL-300. As you can see, the information you completed on the first page has automatically populated into your forms. What orders do you want? On page 1, there is a caption that allows you to summarize all of the orders you are asking for in your request. Check the boxes for each order you want the court to make. The issues you include in the form will be what's decided in court. And if you're modifying a current order, check the box Change. Here's a key point. The judge will not address a request that is not listed in your forms. Make sure you are specific about what you would like the judge to order. On pages 2 through 4 of the request for order, each question is a different type of order you can ask the judge to make. Primarily, each question asks, "What are you asking for? Why are you asking for this? And are you asking to change a current order?" Check the box that corresponds with the request that you are making and fill out the section completely. For example, question 2 describes orders for custody and visitation. Question 2A and B ask what orders you are requesting. Question 2C tells the court why these orders are in the best interests of the child. Question 2D tells the court whether or not there is a current order already in place. Follow this process for each request that you are making. Now that you have completed questions 1 through 9, you may provide the judge with additional facts that support your request. You can list the information on page 4, question 10. If you need more room, you may write your declaration on attachment MC-025 and label it attachment 10. This declaration should be no longer than 10 pages. Your declaration is used to show the facts that support your request. Use headings in your declaration to let the judge know what issue you are addressing and to help keep you focused. For example, write custody and visitation, and then explain to the judge the specific facts that support your request, why it is in the child's best interest for these orders to be made, and any evidence you have that supports your statements. You will do this for each order listed in your request. What do you mean by specific? It is very important that when writing your declaration, you provide detailed information. You will define who, what, where, when, how, etc. For example, a general statement is, "I was hungry and I ate a banana." Here's an example of a specific statement. At noon, I was in the living room. My stomach growled and I realized I was hungry. I walked to the refrigerator. I opened it and saw 6 yellow bananas on the top shelf. I picked out the biggest one, peeled it, and ate it. Am I missing something? Here are some things to consider. Did you check the boxes that correspond with the request you are making? Have you attached all your evidence like receipts, pictures, and text messages? And did you label them exhibits 1, 2, 3, etc.? You also need to tell the court why you're attaching it in your declaration. Do all your parties' names match the initial petition? Double check everything. Step 2. Once you have completed your paperwork, make copies for anyone listed on the case. This will include the forms, attachments, and any evidence you referred to in your declaration. Including the original, you should have at least 3 complete sets of your documents. Step 3. File all your paperwork plus your copies with the court. Be prepared to pay the court costs or provide a completed fee waiver packet. Step 4. Have an adult serve a copy of the paperwork and a blank responsive declaration FL320 on the other party. Depending on your case, this can be done by personal service or by mail. Personal service versus service by mail. Personal service is the best way to make sure the other party is served correctly, but sometimes you must use personal service. For example, when personal service is ordered by the court, when the court granted temporary emergency orders, or when the respondent has not been served with the initial summons and petition, or appeared in the case by filing a response. In some circumstances, you must complete a personal service to change a judgment. If you're not required to use personal service, you may use service by mail. You can check with the Self-Help Center to be sure you're allowed to use service by mail for your request. Your server will fill out a proof of service to tell the court the details of how and when the service was completed. Use either Proof of Personal Service, FL330, or Proof of Service by Mail, FL335, depending on which method was used. Once your proof of service is completed, you must file the original plus one copy with the court. If you're requesting orders for custody and visitation, the court may order you to attend a meeting with a child custody recommending counselor, previously called a mediator. Check your request to see if this has been ordered, and if so, what the requirements are for attending. Lastly, attend your hearing. Some hearings are currently being held by telephone using WebEx. You should receive notice of a telephone appearance with instructions on how to attend. If you have not received a notice, you may confirm your hearing status with the court directly prior to the hearing. That's the end of this video. You can find more information about your case and self-help services on our website at riverside.courts.ca.gov.